My Lord, there is no explanation and evidence or reasons provided to you. Let them put those reasons, comply with that section, give it to the victims, let us respond. My Lord, has this question been faced by other high courts? My Lord, this same question, as you retire to write a ruling, was a subject of discussion.
Proceed, Mr. Mari.
Thank you. This is a question that confronted your brother, Justice Nyakundi, in petition number 15 of 2018 at the High Court in Kajiado. And in page 4, the learned judge put it this way, that is, I'll read, the court will capture it. The emerging jurisprudence in Kenya is the constitutional provisions on victim rights and the enactment of the Victim Protection Act 2014, Section 9, subsection 1 of the Act provides that. Lord, Section 9, Section 1 provides that a victim has a right to be informed in advance of the evidence, the provision, and the defense intends to rely on. I wouldn't matter so much. In essence, Justice Nyakundi pronounced himself that a victim is not a passenger for the state to just decide to charge, the state decides to terminate, the state decides to do the way it wants to do. The state must be accountable, and Article 10, the state must be transparent, and Article 10 of the Constitution, and the state must be responsive. The public needs to know in writing. The victim needs to know in writing, so that the whole world knows the reasons as to why the state wants this matter to go to inquest. Lastly, my Lord, we are not opposing, because the law gives the DPP the power to make this application. But equally, the law demands the DPP provides reasons in writing to the victims. That's all, my Lord. Mr. Cliff will also take a very short time on the matter.
Yes, sir. My Lord, Article 157 is quite clear. When the DPP is exercising that power under the Constitution, he is expected to be acting in good faith. Why do we have a problem with this today? There was no information given to the victims at any particular stage. How this matter was considered, how this conclusion, perhaps let me say, how this matter was arrived at to make that conclusion. Had it not been, my Lord, and this is quite clear, had it not been that we saw this on social media today, we would not have known. It would have been water under the bridge. So going through social media, we realize that this matter is in court. I proceed to court. I find it is actually there. And also inform Mr. Omari. I start questioning him, what happened? If it was in good faith, why did the state keep quiet about it and come and ambush us at this particular moment? Why? Eventually, when the state has realized that we have come to know about this matter, you will notice that this letter was made on the 29th of November. That was yesterday. Looking at the letter, you will see that there are no reasons given as to why they want this matter withdrawn or annuled entered. Knowing that now this matter is in light and we know about it, so what do? Come and do, and now give you reasons orally. Why wasn't it in writing if it was in good faith? Why were the victims not informed directly or indirectly through their lawyers or directly about it? This matter having been then written on the 29th to the court, you will see that quite clearly it denies their victims an opportunity to be able to say something. It is not even 24 hours. How do the victims digest this? How do they respond? How do they even start when they have no reasons given? Quite clearly, this cannot have been in good faith, my Lord. My Lord, the permission of the court then comes in under Article 157, Sub-Article 8. Permission of the court is not only that the court will be told, we want to withdraw, and they say, yes, please do. The court must be convinced, must be given sufficient reasons to see that this is actually a proper candidate for withdrawal. So the reasons given to you are oral, and then they fail to be able to give you in writing, which is a requirement. Are they saying that they do not know this law? Are they saying they are not aware of it? We are saying it's intentional again. And therefore, again, good faith. Is it there, my Lord? It is a question that you'd ask yourself. You're being told that this matter can be withdrawn because statements to the defense had not been given and no documents provided. Aren't these the questions that the victims are supposed to look into as well and answer and give an opinion about it? You're being told that an investigating officer in this case has sworn 2 affidavits. My Lord, have you seen those affidavits? No. Have the victims seen these affidavits? No. Have they been asked their opinion about these affidavits? No. What is in those affidavits that everybody else knows that the victims do not know? Is it something that they can be able to respond to? Probably yes, but we need to see them first. Again, ambush. Again, in bad faith. My Lord, we are being told that once these affidavits had been given, then this should come to a conclusion. My Lord, this is where again your permission comes in. You need to know what this is all about. You can't be overlooked because ultimately we are coming to you and you're the one to give the final word about it. They might have the article in their favor. But to stop this kind of abuse we are talking about right now, this is why we come to you. We are wards of the court as well. Not only the accused person, also the victims. They are wards of this court. Justice does not only go towards the accused person, it also goes to the victims. Issues have been raised like the crime scene, that it should be handed over back to the accused person. Inquest or not, my Lord, a crime scene still remains a crime scene. And if what was being preserved in that crime scene is still there, then allowing an accused person to go back to that place, isn't it a risk? Does the prosecution or the DPP realize this? I hope they will respond about it. And we're not talking about ownership. It is still a crime scene, whether it belongs to the accused person or to the family. The family is not going there. The accused person should not go there. My Lord, it must then be our opinion, and this is what we are saying. We need those affidavits, we need all these issues, the reasoning that came into conclusion that this matter needs to be withdrawn, so that the victims have an opportunity to be heard as they respond. That is all, man.
Lord, that is all. We have no any other issue to raise.
My Lord, just a short... yes, my Lord, I've had the submissions from the first and second accused and also from the victims. My Lord, we believe that on the victims, because the accused persons have supported our application, on the victims, we have informed the court in detail on what the issues are. Therefore, we have complied with the Right to Knowledge and the Victims Protection Act. My Lord, we still believe that we have acted in good faith, and it is in the public interest that this matter move to inquest. All the issues can be canvassed at the inquest stage so that we can have clarity on this matter and a way forward for the victims and the public, my Lord. We again kindly request that you accept our application and have the matter moved and registered in the lower court, the Chief Magistrate's Court.